Hi, Tony DeWitt here, Missouri appellate attorney and a guy who likes to make the law make sense on YouTube. Today we're going to talk about how the Missouri Supreme Court did the right thing and a little bit about Missouri's initiative petition process. Missouri offers its constituents two ways to amend its constitution and two ways to get statutes passed. The first, of course, is the more traditional one, where the legislature decides to propose a constitutional amendment and have the people vote on it. And of course, the other way that they do statutes is they write the statutes, pass those into law. They're signed by the governor, and they become law. That's how, for the most part, 90% of the statutes in Missouri get passed. Maybe higher than that, 95 maybe. But not all of them. And the reason that that's the case is because there is the process in Missouri where individuals can simply get together and petition the government and both pass statutes that don't have to be signed by the governor and amend the Constitution, or at least get constitutional amendments on the ballot so that they can be determined. So let's take a look at that process right now. So the Secretary of State in the state of Missouri has a little booklet that tells people how they can make their voice heard through the Missouri Initiative Petition process. And it briefly explains how things work. So the initiative process gives Missouri citizens the opportunity to directly participate in government, and the Secretary of State's office is charged with overseeing the process. So petitioners first submit proposed petitions to the Secretary of State's office. The office approves the proposed petitions form and prepares ballot summary language, in other words, the language that will go on the ballot. The state auditor also prepares a fiscal note and fiscal note summary for the proposed petition. And that's where it basically tells taxpayers how much money this initiative petition or change in the Constitution is going to cost. The Secretary of State's office then certifies the official ballot title for the petition, which consists of the ballot summary, language, and fiscal note summary. After the official ballot title is certified, petitioners can circulate their proposed petitions and collect signatures. Next, petitioners submit these signatures to the Secretary of State's office. The office distributes copies of the petition pages to local election authorities to verify that the signatures are those of registered Missouri voters in the correct congressional district. Finally, the Secretary of State's office receives the verified signatures and determines whether the petition states a sufficient number of valid signatures. If so, the Secretary of State's office issues a certificate of sufficiency stating that the petition shall be placed on the ballot for the general election. The details of the process are outlined below. And in that little summary there, the Secretary of State skipped one important process. Let's talk about that now. So step one, you submit a proposed petition, and step two, they send it to the auditor's office for a fiscal note. The proposed petition is posted on the Secretary of State's website for a public comment period, and then in step four, the Attorney General's office reviews the form and forwards its comments to the Secretary of State's office within 10 days after receiving the proposed petition. The Auditor's office prepares a fiscal note and fiscal note summary and forwards it to the Attorney General's office within 20 days after receiving the proposed petition. The Secretary of State's office approves or rejects the form of the proposed petition within 15 days after receiving the proposed petition from the petitioner, and the petitioner is informed of the approval or rejection. And then they perform the other steps necessary to get it done and reviewed within 23 days after the approval of the petition's form. Then we go back to the Attorney General's office. The Attorney General's office forwards its review to the Secretary of State's office within 10 days after receiving the proposed ballot summary. The Attorney General's office also forwards its approval or rejection of the fiscal note and fiscal note summary to the Auditor's office within 10 days after receiving the proposed fiscal note and fiscal note summary. The Auditor's office then forwards the fiscal note and fiscal note summary to the Secretary of State's office. Now, importantly, what the Attorney General does is review this for form and legal content. It does not review it for any of the other issues that are set out in this regard. So after that, they circulate the petition, and then they have to get a certain number of votes. So the number of votes goes by congressional district, and what they do is they look at the votes cast for governor. And in 2020, in the first district, there were 320,000, and they go through this little district thing here, and then these are the number of signatures over here on the right that you have to have in order to basically certify anything for constitutional sufficiency. So in order to get the minimum number of signatures that you would need to get in order to get this certified is you have to get 6 of the 8. So you would have to get 171,592 signatures for a constitutional change and 107,246 for a statutory change. So then it goes through the filing procedures and all of that. That's not really important here. This has to be done before you even get the petitions to circulate for signatures to see if it can be put on the ballot. So those are all of the things that you have to do in order to get something in front of the voters in a November general election. Usually those elections are held every 2 years. And the reason that they're held every 2 years, of course, is because you have congressional elections every 2 years. That's how that system works. Now, the situation in the case that I'm going to tell you about came about as a result of Dobbs. Everybody remembers Dobbs, right? It overruled Roe versus Wade, and as a result, there's no federal constitutional right to an abortion. Now, the idea is that if it's up to the states to regulate, the states should regulate it, and that's what Missouri's very Republican legislature did. It regulated abortion almost completely out of existence. So the people of Missouri, particularly several young ladies in Missouri, got together and proposed an initiative petition to put a constitutional amendment on the ballot. And that's where things went south. Let's go through the case and I will explain what happened. So here is the opinion from the Supreme Court of Missouri. It's State of Missouri ex rel, meaning on the relation of Dr. Anna Fitz-James, who is the respondent, and Andrew Bailey, who is the appellant, and Scott Fitzpatrick, who is also a respondent. Now, this was tried in front of the Honorable John Beadham, who is a judge I know well from Cole County. He's a very deliberative judge. He used to be an appellate lawyer, and he knows what he's doing pretty much all the time. So, Dr. Anna James filed a petition in the Circuit Court of Cole County seeking a writ of mandamus compelling Attorney General Andrew Bailey to approve fiscal note summaries for 11 proposed initiative petitions she had filed with the Secretary of State. After briefing and argument, the Circuit Court made permanent its writ of mandamus, ordering the Attorney General to do so and to forward notice of that approval to the State Auditor Scott Fitzpatrick. The Attorney General appealed, and this court has jurisdiction pursuant to Article 5, Section 3 of the Missouri Constitution. Nothing in Section 116.175 gives the Attorney General the authority to question the auditor's assessment of the fiscal impact of a petition. And basically that just says the footnote says it's the revised statutes of Missouri from 2016. Instead, the Attorney General's authority extends only to reviewing the legal content and form of the fiscal notes and summaries prepared by the auditor, not their substance. Because the Circuit Court in this case did not err in finding there was no defect in the legal form and content of the fiscal note summaries prepared by the auditor concerning Fitz-James' proposed initiative petitions, the Attorney General's refusal to perform the plain, unequivocal, and ministerial duty of approving those summaries and informing the auditor he has done so cannot be justified. The Attorney General was to perform that task within 10 days of receiving the notes, and he didn't, a period that expired more than 3 months ago. Accordingly, the Circuit Court's decision to make permanent its writ of mandamus requiring the Attorney General to perform that duty is affirmed. In March 2023, pursuant to the statutory requirements of Section 116.332, Fitzjames submitted 11 proposed initiative petitions to the Secretary. We're not going to go through those. The Secretary posted the text, did everything he was supposed to do. The Department of Social Service, Mental Health, Department of Health and Senior Services indicated they anticipated no fiscal impact other than unknown impact related to federal regulations. The only county to report an anticipated fiscal impact was Greene County, which estimated a $51,000 fiscal loss. Now, I would point out that Greene County is about as Bible Belt as you will get in the state of Missouri. It is the home of the Assemblies of God Church down there, and I guarantee you that it's a very, very religious community. So, again, this $51,000 estimate may very well be the product, much like Andrew Bailey, of politics as opposed to necessarily fiscal impact. All other responsive counties reported no anticipated fiscal impact. Opponents of the initiative indicated they believed the initiatives could risk the state's federal Medicaid funding and result in reduced tax revenues. The auditor received no submission of estimated fiscal impact from proponents of the initiatives. The auditor then created a fiscal note. The Attorney General had 10 days to approve the legal content and form. If the fiscal note was defective in either form or legal content, the Attorney General was to return the audit to the auditor for the revision. On April 10th, the Attorney General notified the auditor that he believed the legal content of each fiscal note was deficient and returned the notes to summaries to the auditor. The Attorney General stated the fiscal notes were deficient because they contained inadequate and divergent submissions from government entities regarding the fiscal impact of the proposed initiatives. The Attorney General also noted that he believed the fiscal note summaries were deficient because, 1, they did not accurately represent the true cost of the proposed measures to local and state government entities because the fiscal notes did not do so, and 2, failed to adequately summarize the submissions the auditor received regarding the potential loss of federal funding due to the proposed initiatives. So the Attorney General went beyond looking at the legal form and legal requirements and went directly to the substance of the fiscal note. That is essentially an attorney overlooking the work of someone who essentially is in an accounting type position. And that's not what the initiative process is designed to have him do. So now the Supreme Court is going to do some splaining here about exactly what his mission really is in looking at these fiscal notes, or both what the auditor is supposed to do as well as what the Attorney General is supposed to do. Let's look at that now. And at the issue in this case is the division of the responsibility it establishes between the auditor and the Attorney General. The auditor shall assess the fiscal impact of the proposed measure. The state auditor shall prepare a fiscal note and fiscal note summary for the proposed measure and forward both to the Attorney General. And then it says what that shall do. And then it says the Attorney General shall, within 10 days of receipt of the fiscal note and fiscal note summary, approve the legal content and form of the fiscal note summary prepared by the state auditor. Legal content and form is something other than the actual audit that is required by, or the accounting issue that is required by the statute. So the first subsection of this statute plainly and unequivocally assigns to the auditor, not the Attorney General, the task of assessing the fiscal impact of the proposed measure. And that's pretty much where they hang their hat. The subsection 2 requires the auditor to present his assessment in the form of a fiscal note and send both to the Attorney General so he can review their legal content and form. Section 3 sets the only legal content and form requirements. that both shall state the measure's estimated cost or savings, if any, to state or local entities, and the summary shall contain no more than 50 words, excluding articles, A and the, that sort of thing. And 3, the summary shall summarize the fiscal note in language neither argumentative nor likely to create prejudice either for or against the proposed measure. Subsection 4 lies at the heart of this case. It provides the Attorney General shall, within 10 days of receipt of the fiscal note and fiscal note summary, approve the legal content and form of the fiscal note summary prepared by the state auditor. The subsection does not require or even authorize the Attorney General to approve the legal content and form of the fiscal note, only the fiscal note summary. And as noted above, subsection 3 only sets out the legal content and form requirements that are at issue with which the Attorney General has to concern himself. Even if the Attorney General were authorized to approve the legal content and form of the fiscal notes, his argument extends well beyond the legal content and form requirements set out in section 113.175. The Attorney General challenges instead the substance of the fiscal notes, and the court says you don't get a chance to do that. This court has often repeated the importance of the right to initiative enshrined in the Missouri Constitution. Nothing in our Constitution so closely models participatory democracy in its pure form. Through the initiative process, those who have no access to or influence with elected representatives may take their cause directly to the people. The people, from whom all constitutional authority is derived, have reserved the power to propose and enact or reject laws and amendments to the Constitution. And that was quoting Missourians to Protect the Initiative Process, a 1990 case filed against Matt Blunt. For more than 40 years, this court has noted that the procedures designed to effectuate the rights of the initiative and referendum should be liberally construed to avail voters with every opportunity to exercise these rights, and the ability of voters to get before their fellow voters issues they deem significant should not be thwarted in preference of technical formalities. If technical formalities cannot stand in the way, a failure to perform a clear and unequivocal duty must not be allowed to do so either. If the Attorney General had complied with his duty to approve the auditor's fiscal note summaries in the time prescribed by Section 116, the Secretary would have certified the official ballot titles for Fitzjames initiative petitions nearly 100 days ago. For the reasons set forth above, the Circuit Court's judgment is affirmed. Well, as you can see, the Missouri Supreme Court reached the right decision for the right reason. Now, interestingly enough, most of the justices on the Missouri Supreme Court are conservative, and with the exception of maybe 2 of them who might be a little bit liberal, most of the time the results in the cases are 6-1, 5-2. It's very rarely do you see a really split court in Missouri, because for the most part they try to work toward consensus, I think. Now, I can guarantee you that the conservatives in this Supreme Court do not want to see abortion made a constitutional right. I think for the most part they are constitutionalists who believe very strongly that the people should have the right to put that on the ballot, but they themselves would not support that. And that's a really great thing about an initiative process, because in an initiative process, those 7 votes only count once, and there are a whole lot of other votes in the state that count just the same. The only time those votes count more often than the others is in a situation like this where they have to decide an issue. So even though I think for the most part they would not be in favor of the amendment, they still did the right thing here by putting it on the ballot. And it's important to remember that Missouri is unique, I think, in many ways, in the way it interprets its initiative process and in the impact of its initiative process. Interestingly enough, several years ago, there was an initiative statute that was passed that was aimed at puppy mills. And it was aimed at stopping the idea that you can raise puppies in terrible conditions and then sell them in bulk to, people who would sell them on to consumers. And it was a very well-crafted statute. The initiative process worked. It got on the ballot. It passed overwhelmingly, and the first thing the legislature did when the legislature came back into session is they amended it to conform and reduce the requirements against the people who were doing the puppy mill stuff, which is a flaw in the initiative process. Once the people pass a statute like that, it should be the people that amend it and not the legislature, but that's not provided for under our Constitution in Missouri. So unfortunately, if you want to change something, for example, if you wanted to overrule the Missouri law on abortion, you wouldn't choose to do it on a statute because the legislature could simply turn around and put it right back on the books. So what you have to do is you have to do what Ms. Fitzjames has done here, which is to put it in as a constitutional amendment. Missouri's motto is, "Let the will of the people be the supreme law of the land," and in that case, it would be. So thank you very much for watching. I hope this has been inspirational and educational and all the other things you could think of. And as always, if you have the opportunity today, try to do a kindness for someone. Doesn't have to be a big kindness. Just let somebody go in front of you at the grocery store, or let somebody go in front of you at a four-way stoplight, or four-way stop sign, I should say. Four-way stoplights really don't exist, I guess. I guess they do. Never mind. Let somebody go in front of you at a four-way stop. Down here in Alabama, when you come up to a four-way stop, there are at least 3 people going, come on, because they're not in a big hurry. In the summer down here, it's hot, it's miserable. There is no reason to be in a hurry. So thanks again for watching, and we'll catch you down here at the beach next time. If you like this video, here are a few others you might try, and don't forget to subscribe. Have a terrific day, guys.